The Supreme Court of India 3 days ago just issued a notice on the Digital Personal Data Protection Act of 2023's validity. And that does raise a question whether companies, businesses, or startups should be continuing the process of compliance of DPDP.
So has the DPDP Act been stalled for now? That is the kind of question we are hearing from some founders and SME owners.
Right.
But we don't think anything like that has taken place. This is false information.
Right. So let's just first let you know what the notice is issued about. So Civil Liberties Union have challenged the validity of Digital Personal Data Protection Act in terms of whether it is curbing the RTI Act's sections, which actually gives government some arbitrary power and gives them more immunity in terms of accountability. Secondly, it's who benefits at the end of the day when any data protection breach happens, and who becomes the beneficiary, whether it is the data protection board or if it is an individual.
So they have filed the issue in these again with this specific points, like what is the broad scope or definition of personal data in as defined in section 2T of DPDP Act. Then they have also raised concerns about the amendment to RTI Act, that is section 81J through section 44(3) of DP Act. And they are also raised an objection related to state exemption under section 7 and section 17(2)(a), allowing government surveillance or data processing without standard restrictions. Then another issue arose, and that is related to lack of clear distinction between genuinely private information and data relevant to public accountability. And another point which has been raised was the broader concern related to like potential dilution of RTI and risk of state surveillance, no adequate compensation for data misuse, and executive dependent structure of DP board. And the main argument by the petitioners were that DPDP could use privacy protection to undermine transparency and journalism and accountability.
So, what validity issues is being concerned in this particular petition at the Supreme Court is majorly about how government is being secured, but it does not have anything in relation with how companies, startups, or businesses should comply in terms of Digital Personal Data Protection Act. So I would say if you're thinking, okay, the time has come, we should stall on our practices to create compliance for the same. No, it's not true. The consent manner remains the same. You'll have to get consent of the user. You'll have to create a grievance officer. You have to create DSR, which is data subject rights, which is in accordance to the DPDP Act.
Right. So not much has changed per se, and this is more of a legal battle which is being fought in the courts related to enlargement of the legal concepts like privacy and transparency, which honorable courts in due time definitely would put a stable answer to such debates. And they also keep evolving as the time changes. So nothing has changed per se for the companies and its implementation related to DPDP compliance. Neither other sections of DPDP Act or other provisions of rules have been challenged. So the challenge has, as we discussed, is not related to how the law needs to be implemented, whether there would be a DP board or not. They might have questioned its dependence on executive, but they have not per se raised that validity or relevance of DP board itself. So there would be a DP board which would be imposing fines after the hard deadline has reached, and that will be May 2027.
And it has been already 4 or 5 months which have been passed in the hard deadline of 18 months. And the time only gets lesser. And with lesser time, haste will begin further. And in haste, there are chances of, errors in terms of compliance. And also, when the compliance timeline is shortened, it becomes difficult. And also, significant data fiduciary have to comply much earlier than that.
Yeah, and God forbids if, uh, as one scenario, that if the definition is made more stringent for the data or digital personal data. So if the personal data becomes even more stringent as per the judgment in the future, then the companies needs to be even more cautious, because then the more litigation would result out of the same law and its implementation. So we only need to utilize whatever time we are left to implement the DPDP provisions, rather than uh, thinking that it might get delayed or it might get completely thrown away. So as of now, nothing like that is going to happen.
I mean, it's like sitting over a mine. You don't know when it's going to explode, and just sitting won't help. You have to actually take measures right now. And as we've previously mentioned, you should actually start creating a budget for the same, so that at least there is some amount of funds defined clearly that this will go into compliance. Secondly, you also have to figure out what personal data actually attributes to, because most of the business owners and founders think, oh, I'm taking publicly available data and scraping through contacts to maybe even get leads. But you're mistaken there. If I would say that if that public data is able to identify any individual, that becomes a personal data. So I think one should start acting early, don't you think?
Correct. So the time is not increasing, because earlier also government has indicated once that they are thinking of shrinking the timelines from 18 to 12 months, for which organizations like IAMI has approached the uh, government and the court that that should not be shrunk, because that then the deadline would be so close that they won't be able to implement. So larger companies have already taken in stock, but the major concern remains with SMEs and uh, new startups who have not yet even started gathering information about the kind of data they are collecting, where the data is going, who are all the processors, where the server of those processor or their own uh, servers for their third party services are there. Because one of the provisions says that they should inform to the user where their data is being stored, and also a DP board someday can state them that the server should be brought back to India. So for such provisions, the organization needs to be ready. They cannot do it overnight. The changes of servers takes time.
Right. Also, if you think as a business owner or a founder that where should you actually start, we'll just give you a quick, easy tool that we have created, freescan.complydp.com, which we have also mentioned the link in the bio. So you can definitely go and just put your website URL so that you can understand at what particular stage your website in, how much of compliance is required, and also, if you think that you want to just understand what's the first particular action to be taken, just comment help, and we'll get in touch for the same.
Yes, and we would request you that you start working as soon as possible.
Right. So that's it from our end today, and we'll keep you updated with the new privacy laws and any personal data protection act changes or amendments in case.
Yeah, and next hearing is on 23, so we'll keep you updated.
Right. So until then, see you.
Thank you.